In this video, we'll discuss the remaining portion of guardianship in Islam, and in that connection, we'll discuss first de facto guardian and how it is being defined by Tabji. So, a de facto guardian is a self-appointed guardian. According to Tahabji, in his Mohammedan law, a de facto guardian is an unauthorized person who, as a matter of fact, has custody and care of the person and property of the minor. The continuous course of conduct in respect of minor's property by a person makes him a de facto guardian. Otherwise, it means that a person having no right to do so assumes the charge of another's estate and carries on the administration and management of the estate. This continuous course of conduct results in conferring on him the status of de facto guardian with certain liabilities and obligations. And now we'll discuss the very powers of natural guardians and testamentary guardians as provided under Section 27, 29 and Section 33 of the Guardians and Wards Act 1890. So, as per the Hidayah or Darul Mutar and Fatwa Alamgiri, they provide different powers of guardians. In general, these are contracting a child in marriage, buying or selling for the child to satisfy his needs, and accepting presents and gifts and keeping them for the child. So, the first powers, as Muslim jurists expressed the view that a guardian has wider power over the movable property of the minor than over the immovable property. A guardian can sell minor's immovable property under the following situations. The first one for the day-to-day maintenance of the minor, and the second one in imminent danger of being lost or destroyed, and the number 3 condition for the advantage of the minor, and the fourth one if it fetches double of its value, and number 5 for payment of legacies, and number 6 upkeeping is more than the cost of the property. And the second important powers relating to natural guardians and testamentary guardians has to some extent the power to grant lease of the minor's property only if it is advantageous to the minor and for the maintenance of the minor. Any lease should not be beyond the period of the minority of the child. And the third one, the guardian has also the power to carry on trade or business and invest the minor's property only for the benefit of the minor, but could not involve the minor's property in speculative business. And the fourth one, further the guardian has the power to incur debts for the minor and the power to execute promissory note on behalf of the minor. All such actions of the guardian must be for the benefit of the minor. And regarding the fifth one, the guardian has also the power to partition the property of the minor if there are some other legal heirs. In every such partition, after handing over their share, the rest shall be retained by the guardian on behalf of the minor. And the sixth one, besides these powers, a guardian appointed under Guardians and Wards Act 1890 enjoys the general powers and obligations of the guardian as provided under Section 27 of the Act, and Section 29 provides the limitations regarding sale, transfer, gift, mortgage, lease beyond 5 years without the prior permission of the court, and Section 33 empowers the court to define and restrict or extend the powers of the guardian from time to time. And the seventh one, a de facto guardian has no power to sell or alienate the minor's property. All such acts will be held void. He has also no power to lease, petition, executing promissory notes on the minor's property, as it is held void under Islamic law. But he can borrow money to meet the urgent needs of the minor. So these are the powers of natural and testamentary guardians as provided under the Guardians and Wards Act 1890 under Section 27, Section 29 and Section 33 of the Act. And in our next upcoming video, we will discuss the very conclusive portion dealing Sufa, which we have left by mistake.